Hi, I'm Jonathan Whitcomb. I'm a patent attorney for She & Finney, and today I'm going to be discussing various ways that an organization can benefit from patenting its inventions. I'll be discussing first an overview of patent basics to get us all on the same page, talking what it means to be an owner of a patent, because in order to monetize a patent, you have to own it. And then we'll get into the meat and potatoes about monetizing patents. Starting with the basics of patents, we'll discuss different types of patents, what is an invention, and what is the government interest? Why does the government care and offer a patent system at all? There are three basic classifications of patents. There's a utility patent, which is talking about how a patent is going to be used, or what a patent that can be used for something useful. There's a design patent, which is entirely based on the ornamental appearance of the invention. And there are plant patents based on biological advances. For the purpose of today's presentation, we're just going to be limiting this to talking about utility patents. But the ideas here can be used for any of the three types, any of the types of inventions. So patents protect inventions, not ideas. In general, an invention for a utility patent is a device or a process that provides a useful, practical solution to a problem. Merely identifying a problem to solve and then describing its advantages for that solution, that's not an invention. For example, you can't patent a flying car merely by describing how cool a flying car would be, and all the wonderful things it would do for you. The patent application for a flying car would have to describe the specific mechanisms needed to make that car fly. So a patent generally describes how the invention solves a problem and what the invention is itself. So what kind of inventions are patentable? The scope of patentable inventions includes any new and useful machine or device, a process or a method, a manufacture, or a composition of matter, or any new and useful improvement of any of the above. A device claim in a patent may encompass, for example, mechanical devices, which generally tangible things you can hold in your hand unless it's very large. Software inventions, which are intangible, and systems, which may be a combination of two or more devices. A device patent protects what the device is, not what the device does. So a patent for a device invention would list its structural characteristics. For example, a list of parts or components that make up that device and how they interact with each other. For a process patent or process claims within a patent, a method patent, synonymous with a process patent, a method patent protects a procedure, which would be a list of functional steps to accomplish a task. I do step one, I do step two, I do step three. So for example, the process could be a process for manufacturing an item. The method may be tied to a device, and a single patent may both include device claims for what the device is, and then process claims for example, how to use the device. The method may be computer implemented or software. Another type of patentable invention is an article of manufacture, for example, textiles, tools, footwears, any number of things. The composition of matter is also patentable. Examples of compositions of matter include material compounds such as polymers, semiconductor materials, or a cement mixture. So why is the government involved? What does the government interest in all of this? The policy goal of the patent system is to spur the economy by encouraging innovation. Patents provide the inventors a tool to protect their inventions and profit from their development efforts and investments in research and development. The patent is a bargain between the inventor and the government. So the inventor discloses the invention to the public in sufficient detail so that the person reading the patent understands the invention and is able to actually practice the invention. And in exchange for this disclosure that contributes to the overall technology level of the country and the world, in exchange, the government gives the inventor a limited monopoly. And we'll talk about that a little bit. A patent gives an inventor a limited monopoly to prevent others from making the invention, using the invention, selling the invention, or importing the invention. So you don't need a patent to practice your own invention. What the patent does is give you a mechanism to prevent others from doing so. So in the United States, the inventors own the patent rights by default. So inventors must be named in the patent application, the inventors of the device being or the process being invented. When a patent has two or more owners, for example, initially two or more inventors, each of these owners may fully practice the invention and may practice the invention without the permission of the other owners. So for example, one owner may assign or license the invention to others without the consent of any other co-owner. So how do you make money off of patents? Well, there's several ways. Most basic is by practicing your own patented invention. You can assign the patents to others. You can license the patents. Patents can be used as an asset, as any other financial asset can be used. And there's several different strategies for being able to monetize patents, and we'll touch upon these. So yeah, the basics of patenting your invention and preventing others from doing so. Your business directly provides the patented product and services. So your company's developed an invention, you've manufactured it if it's a device, and the way that you benefit from it is by making sure you're the only game in town. You have the right to prevent the others, any other party, from using, making, or selling your invention without your permission. So the patent gives you this limited time monopoly for typically 20 years from when the patent application is originally filed. So a patent is a disincentive against others practicing your invention. So the patentee can enforce the patent against an infringer, someone else who's practicing the invention without your permission. That's what an infringer is. The patentee can send a cease and desist letter, notification or letter to the infringer, which is essentially an indication that if you don't stop practicing my invention, we can take it a step further. And the next further step may be patent litigation. So if you don't have the patent, you can't take advantage of this. So patents could be thought of as being a license to sue. If you've invented something and you want to prevent somebody else from being able to practice the invention, you need to have the patent. You can make money by transferring your patent rights. So different ways of doing this are by assigning your patent, by licensing your patent, or taking part in what's known as a patent pool. We'll talk about each of these. So the patent assignment is selling a patent, and it transfers the ownership of the patent to another party. So generally, the assignor, or the person who owns the patent, will transfer the patent to the other party for financial compensation. And again, if a patent has multiple owners, each owner may independently assign her patent rights without any input or from the other owners. So it's important to establish who owns the patent, and if you are an organization and you want to be able to profit from it, perhaps you want to try to make sure that you entirely own the patent. It's important for a business to ensure it owns the inventions by its employees and contractors. So this typically involves an agreement where each inventor assigns his invention rights to the business. For example, the assignment can be part of a condition of employment for in an employee agreement, for example. So patent licensing is a way for a party, a patent owner, to maintain owners of the patent while allowing another party to practice the invention, for example, in exchange for royalties and or a lump sum payment. The licensing allows the patent to grant the third party specific rights to practice the patented invention. So a patent license may delimit specific aspects of the patented invention. The license may be, for example, duration limited. So you can say the licensee may practice the invention for a certain amount of time, from 2024 through 2027. Likewise, a patent license can be geography delimited. So the license may specify that the licensee can practice the invention in territories, U.S. territories east of the Mississippi River. The licensing can be done according to how the licensee may practice the invention. For example, a field of use license may permit the licensee to practice one or more of just manufacturing the invention, selling the manufactured product, or just to use the invention. And different parties, the licensor, the patentee, may have agreements with several different third parties that give specific rights in each individual license. A license by application allows a licensee to practice the invention for a specified application. So we'll take the example of a patent for a semiconductor material. So licensee number one for the first license can practice the invention for medical applications. A second licensee can practice using this semiconductor for defense applications, and a third licensee might be able to practice this semiconductor material invention just for industrial applications. So there's several ways to slice up the pie with licensing, and the license may specify a combination of these factors. So, for example, a license could stipulate a 4-year license to manufacture a device for medical applications in California. So here are the aspects of licensing specify the duration, the use, the application, and the geography of the licensee's rights to use the application to practice the invention. The patent license may be limited to specific patent claims, and not getting too far into the weeds here. A patent can have both device claims and method claims. So what the invention is and how it's being used. So a first license may just license the rights to practice the device claims, and the second license may have the licensee may have the right to practice the method claims. So one party can make the device, and the other one can sell the device. Lots of ways that this can be divided up, and that can be leveraged by the patent owner to be able to work with a lot of different companies and different organizations. There's a way to combine assignments and licensings. For instance, an assignment with a license back. So while the assigner may and typically transfers all the invention rights to an assignee, it's common for the assigner to negotiate a license back from the assignee, so the assigner may continue to practice the invention even though they no longer actually own it. So they get the benefit of being able to assign the invention to the third party, and still be able to practice the invention themselves, perhaps in a limited manner. Then there's cross-licensing. A patentee may be prevented from practicing the patent that they own due to another party's patent. So, for example, if you have patented an improved method for manufacturing a product, but that product is claimed in a patent by another party, then the product's patent holder can prevent you from manufacturing the product because they own the patent for the product itself. But you've improved the way of making it, and therefore you can prevent the product's patent holder from using your improved manufacturing method. So here, each party could benefit from the other's patent. And with a cross license, you give the product owner a license to practice your manufacturing method, and the product owner gives you a license to manufacture the product. So win-win. Patent pools are a more recent way of different patent owners being able to share patent rights. So patent pools are similar to cross licenses. A patent pool is an arrangement between two or more organizations to license one or more of their patents to one another or to third parties. So patent pools may be associated with complex technologies that need complementary patents to provide efficient technical solutions. Okay, that's a mouthful. Let's take a look at an example. Here, a smartphone involves multiple technologies that may be developed by different parties. So one aspect of a smartphone is the telephone functions itself. So a telephone has a microphone and a speaker, and there may be one party that has patented the microphone and another party that's patented the speaker that fits into the small smartphone enclosure. Another party may have the patent rights to the wireless transmitter or wireless receiver that's being used by the smartphone. Another party may have the patent rights to the touchscreen interface on your smartphone. And another party may have patented the enclosure for the whole package. Here, the parties can pool their patents for mutual benefit. Patents can also be used as an asset. Patents may be deemed to have some monetary value. For example, the monetary value may be determined during what's called a patent valuation process. So a strong patent portfolio can make a business attractive to investors and for those looking to acquire the business. A strong patent portfolio in a given technology can encourage potential investors, business parties, business partners, et cetera, to work with your company rather than compete. So they say, we want to get into this field, but it looks like your company's kind of cornered the market. So rather than trying to reinvent the wheel here, we're going to work with you to partner up and work together for the product. And patents may also be used as collateral for loans. Finally, there are two patent strategies for businesses to consider. One is patent harvesting, which is a review of in-house innovations by an organization to discover value that they may not have thought of, and we'll get into that in a moment. Another strategy is defensive patenting, so patenting inventions that you do not intend to enforce against others. So first, patent harvesting. And this is typically for an organization that has two or more development groups, and those individual development groups may be independently developing their own products. So patent harvesting involves meetings within the organization for the different development groups to present their innovations to each other. So here, one group's trash may be another group's treasure. And so, for example, the first group may have discarded an idea because they didn't find it being useful, and it turns out it shoehorned perfectly into the second group's invention. So individual innovations from different groups may then be combined into patented inventions to produce value for the organization. So organizations with two or more R&D groups may benefit from periodic cross-functional patent harvesting meetings. And because there can be some time considerations, all this. So the rights to an invention may be lost to failing to file a patent application in a timely manner. So there's what's called statutory bars. It's a time limit in the United States. For example, you have 1 year after disclosing your invention to file for a patent application. And so in case one group in the organization doesn't realize that this particular aspect is important, they disclose it, they haven't filed a patent application in a year, and they've lost the rights. So if these groups were aware of each other's inventions in these patent harvesting meetings, those could have been protected. And similarly, if the invention is not patented in a timely manner, another party that independently invents the invention itself could leap the line at the patent office and patent the invention first. And so timely patent harvesting meetings can be very important to an organization to make sure they know what they have. They can realize benefits the individual groups didn't consider themselves. Moving on to defensive patent strategies. So a company may patent its invention even when it does not plan to enforce its right against infringers. Obtaining rights to an invention can prevent other party from obtaining the patent rights and enforcing them against you. So you've invented your widget, you decided to patent it, even if you're not planning on suing anybody else for practicing your widget. But if the other party comes in and patented it ahead of you, they could enforce their patent against you. So getting the patent yourself prevents you being stopped from practicing the invention and having to pay license royalties to the other party because you didn't bother to patent the invention yourself, even if you invented it at first and chose not to patent. Another purpose for defensive patenting is horse trading. So in a crowded technology field, having a stable of patents that gives you something to trade with a competitor who accuses you of infringing their patents. For example, you may have a patent you could assert against the competitor that's accusing you of infringement. So they say, you're infringing against me, we're going to sue you, and you come back and say, no, well, we could also sue you. So instead of suing each other, let's come to a happy agreement where we cross-license our patents and stay out of court. So while defensive patent strategies may not directly benefit the bottom line, they can help avoid potentially costly litigation or loss of rights to practice your own invention. So that's been a brief overview of how you can benefit from patenting your organization's inventions. If you would like to discuss this and other related matters, I'd love to hear from you. My contact information is here, or you can contact us by phone. You can reach us at She and Finney's website, and we look forward to hearing from you, and thank you for your time.